So hi, this is the second part of the video. I mean, that was getting very long, like very long, 45 minutes. I mean, that's a lecture that I have just given right now. So I understand it's a bit long, so bear with me. I mean, jurisprudence is something which very much fascinates me, and I want to make it as simplistic as possible so that you can understand it. Caveats are that jurisprudence is basically a very primordial subject which basically has a very analgesic concept to it. It's basically something which is very historical and predates to natural law. So many theorists and many scholars tend to associate legal jurisprudence or legal philosophy with the kind of concepts and systems that are associated with it. So they say that there is particularly natural law, there is particularly historical law, there is particularly sociological law, there is critical legal theory. So they just associate it with different theorists and then they bring out these laws. However, you should understand jurisprudence from that sense, because what my professor used to say to me is that you should understand jurisprudence from a picture point of view. That you are drawing a picture in your mind, that basically what you believe, what your understanding of jurisprudence is from a very basic perspective, and then you are connecting the dots. This is a very Jordan Peterson kind of a approach that I follow. Is basically the castle memory approach. Basically, I associate properties in my head to various buckets of places in which in a particular castle where it is to be located, and that stays in my memory because I associate it. Okay, here it is what is written, so I can contrastingly I can understand that someplace else where something else is written might be different from what I found out in the previous bucket which I have analyzed. So it helps me, it gives clarity. Now what I want to talk about in this video is that what we understood in the previous video, if I give a gist of it. So basically I talked about the perspective of law from a linguistic analysis, the perspective of law from a descriptive normative analysis, the perspective of law from a very analytical analysis. I gave you the perspective of HLA Hart's theory contrast. I didn't contrast it, but rather I gave you the two substratums under which the law is situated. Basically, the modular conception of having multiple purposes with which a law serves its purpose. It can be different purposes. And I told from a Swiss Army knife perspective, I gave an example out of that. And second I talked about is the functional aspect of it. Basically the essential function, the essence of what the particular thing is. Like a saw is used for sawing or a hammer is used for hammering, so it has a singular purpose, it doesn't serve any multiple purposes. So I didn't yet delve into the functional aspect of it. I delved into the modular aspect of it, gave you a gist of what HLA Hart's theory is. HLA Hart's theory he's a legal positivist. He was a modern theorist who basically conceptualized the positivist camp, which I am pretty much fascinated about. So he has talked about how law is a synthesis of primary rules and secondary rules. Primary rules govern what you should or should not be doing, what you ought to do in a particular situation, and secondary rules gives the power to officials or judges or referees to basically see whether or not the participants in the game are violating or following the primary rules or not. That's simply what they have said, and I have given this theory from a football perspective because I love football. I'm a Manchester City fan, as I've told you. So now what I want to talk about is that as we understood that law can be a semantic question, law can also be considered as a metaphysical question. What I mean to say is that philosophers want to dabble with this thing called what is the nature of a particular thing. We saw how Socrates, Aristotle, they justify the nature of properties. They want to associate justice to some property or a nature or an essence. So old classical thing about knowledge, let's say, is, as a definition, is that it is true justified belief. So it has three essential properties: truism, justification, and belief. We need to follow what are the necessary implications of what makes a property have which it could not fail to have. So what makes law, and if that law doesn't have that particular property, it fails to become a law. This is what the philosophers of law are much more dealing with, because what considers within law is a very identity oriented question. The essential properties are its identity. The second is the necessary implications. Necessary implications doesn't always convey the identity or essence of the properties. So I'll give an example. Mathematicians are concerned with the necessary properties of a number, let's say 2. What do we consider 2 as? It's a number that comes after 1, right? So this is the feature of an identity question, that it comes after 1. That's how we know the order of numbers. That's how we respect the mathematical system of order of numbers. But mathematicians are not concerned with that. Mathematicians are concerned with the necessary implications of it. What are the necessary properties that you can cull out from the number 2? It's a prime number, it's an even number, so it can be used to... So there are multiple purposes with which it serves. So there the mathematicians are much more interested in. Philosophers of law basically understand what makes law from a very identity oriented standpoint as well as necessary implicated oriented standpoint. So analytical jurisprudence or analytical jurists consider what law necessarily follows from the what basically necessarily follows from the word law is, and not simply its identity. That's what the positivists or the analytical jurisprudence talk about. However, I want to deviate a bit and I want to talk about an essential feature of, from an analytical standpoint, is what is considered as legal fact. Now you have to understand that in a particular society we have a legal system. So we understand that in US there is a particular legal system, in India there is a particular legal system. We know that US follows a presidential system, in India we follow a bicameral legislature executive oriented system where we have a cabinet oriented government, which is basically the main government rather than president issuing executive orders and making laws. We also know for a fact that in, let's say, in a state like California in US, driving above 65 is impermissible. So these what constitutes within a legal system as a particular way of how things govern are legal facts. Now if you make a list of what are the basic metaphysical laws that operate in a universe, you might see there are magnetic fields, you might see there are particularly space-time, gravity, there is many things. But the ultimate metaphysical facts which will not contain the legal facts is that legal facts existence depends on other basic facts. Understand? So normative philosophers or analytical philosophers, where I understand that how positivists would always get right, is that law is ultimately based on basic facts. Normative philosophers say that law is moralistic standpoint, it's not analytical, does not contain description, whereas I have highlighted from a utilitarian standpoint, how will you say that a particular cause X results in the ultimate beneficial advantage to the maximum number of people through result Y without knowing the implications of what affects the result X, how it result Y, how it came into its being as its existence vis-a-vis the cause X, how it happens, what are the necessary implications to it. So they are grounded, they are based on each other. So where normative theory goes wrong is the normative theory assumes the moralistic standpoint from a very interpretivist Dawkinian model to say that it best fits and justifies the law is a completely moralistic endeavor. They fail to understand that law is grounded on facts, which can be legal facts, which basically legal facts can be grounded on more basic facts. This grounding is what the positivists are basically arguing and they are support of. They are not saying or they are not denying whether law depends on morality or not. That Dworkinian enterprise is already covered in the inclusive legal positivism. What I basically want to point to you through this video, second part, is that legal facts is grounded upon basic social facts alone or social facts and moral facts. These two are mutually independent of each other, in the sense that either social facts alone can exist or social facts as well as moral facts can exist. Moral facts cannot independently as a singular entity exist without social facts. You can't say that a particular law, let's say it violates the natural justice principle, because there is no parliament, because there is no judiciary to enforce it, because there is no executive to make such a law, or legislature to make such a law, or executive to execute the law, or the judiciary to enforce the law, because these organizations don't exist simply because it violates natural justice, you simply come to the conclusion that that law is binding on me. That is false, because that's what Hart says. Hart says that there must be someone from a neutral standpoint who has to look into whether or not you are offending the primary rules, or whether or not you're playing the game correctly or not, with the necessary caveats that I pointed out, that it might be contingent also in some cases and it might be necessary also in some cases. But besides the point, what I'm simply trying to mean is that legal facts cannot independently depend on moral facts alone. You need to have social facts. Now, why is this important? It's important because the first reasoning that I said, that it depends, legal facts depend on social facts alone, is a reasoning that delves into legal reasoning as a separate entity without involving moral reasoning, because it exists. The entire point of positivism is this only. They say that a rule of recognition as a master rule is created to give validity to other laws or other rules, is simply because it exists, and as a practice of officials they follow it, so that it becomes a historical and a sociological account, which is why differentiating it into historical and sociological accounts is also very meaningless for endeavor for me, which I believe that positivism or analytical jurisprudence already covers it. But the point which I want to make is that there can be legal reasoning which can exist without moral reasoning. So for a legal positivist, he can argue that law can be related to brute political power, like Austinian positivists would say. But a Dworkinian camp would say that law doesn't depend on political actors alone. See, here what is basically, you want to understand one thing. Dworkinian camp says that law doesn't exist alone with political actors, but there are deeper truisms or truths which exist from a natural law standpoint, which basically applies on law, which is basically the morality standpoint. But you need to have the political actors to exist to enforce it. Otherwise, that law will be meaningless. Simply because it violates natural justice principle is not a ground for which one should be basically adhering to that particular rule or not. Otherwise, what difference does it make for me to be in a legal system if I simply say that if you ought to do cheating, then you would be hanged to death? Let's say that's what Iranian legal system talks about. But let's say in a liberal, much more politically progressive system like US might say, if you do cheating, you might be rewarded with an extra mark because you have the skill to analyze what another person is saying and also interpret it in your own words. Essentially like how you're using AI nowadays. You get rewarded for that. Instead of getting stoned to death in Iran, let's say you will get rewarded in US. So the point is that these two legal systems exist. The distinction between them will itself disappear. If you say that law doesn't only is not to be considered only from a moralistic standpoint, is only to be considered from a very you may say from a moralistic standpoint without having political actors, then the essence of political ideologies or systems with which you demarcate a legal system between one system in US vis-a-vis Iran will simply vanish. I mean, that is where the hypocrisy is of the Dworkinian camp. For a legal or positivist, you may be ought to obey the law. You may say that there is a law that exists. Moral theorizing might be important in order to obey that law. Whether it's morally permissible for me to know that if I smoke in public, I might be getting fined. So that's a moralistic obligation upon me. You might question that, or you might have to adhere to it because that's what the parliament or that's what a higher judicial official or who is been practicing this theory from a neutralistic standpoint is enforcing and adjudicating upon these rules. So you can argue from that, but I am simply concerned about the nature of law itself, and this is the whole crux of my part 1 and part 2 video, is to talk to you about nature of law. Because nature of something, when you talk about nature of something, so you are basically arguing on the necessary properties or the necessary implications rather than the identity itself. So you are not simply looking at it from a linguistic philosophical perspective, you are also looking at it from a philosophical perspective which considers the essence or denotationist as well as a hybrid of it, or a essentialist concept or a functionalist concept or a modular concept as well. So you have to keep this in mind. We are concerned about the nature of law. We are not yet concerned about whether it's morally permissible to obey the law or not, because for which you can use moral theorizing. Positivism doesn't stop there. Positivism simply looks at the nature of law to argue whether or not this legal rule identifies itself with this particular legal system in terms of whether it complies with the master rule, which is the rule of recognition, or not. That's it. Now, natural lawyers may also say that there are complex moral theorizing to it. I'll talk about Radbruch formula, I'll talk about Fullerian 8 desiderata to argue whether or not a particular legal system is corrupt, and that is why an unjust law is no law at all, which is basically the natural philosophical standpoint, naturalistic laws philosophical standpoint is, which is kind of very obnoxious, because if an unjust law is no law and not, then how did the Nazi Germany exist? How did that legal system operate? How did Soviets operate? So the debate between what facts depend ultimately on legal facts is not only a debate between legal positivism and natural law, but also a debate about the necessary properties of law. We are questioning and debating what is the nature of law. We are not considering about whether or not the identity of law with which it associates itself is something which is basically moralistic or something which is descriptive or doctrinal. We are not concerned about that. We are concerned simply about whether or not the nature of law with which we are arguing, whether it grounds on the basis of social facts alone, which is the legal positivists, like hardcore exclusive legal positivists like Scott Shapiro or Joseph Raz might argue about, or might say that legal facts can also be grounded upon social facts as well as moral facts, which are being said by inclusive legal positivists, and where Dworkin budges in to say that it simply exists as moral facts, which is completely a misnomer, which I totally disagree. Now, in conclusion, what I want to say, all things considered, the world is not a happy place. The cycle of injustice, war, hunger, exploitation, corruption, racism, sexism, disease, and poverty seems an inevitable feature of our planet. 40% of whose population 3 billion people lives in poverty, earning less than $2 per day. The gap between the rich and the poor is increasing day by day. 1 child in 6 is born underweight. Every year, 1 child in 10 dies from waterborne diseases or malnutrition. Women constitute 70% of the world's poor, and the most are in the global south. They work harder but earn less than men. They are more likely to be undernourished as a consequence of this discrimination as to misallocation of food. Nor are there many signs in which this situation is improving. There is famines, there is environmental degradation, there is disease which is wrought by COVID, AIDS, deforestation, natural disaster, war, which are ultimately very endemic to this third world that we are living in. It's very endemic, whatever is happening. In the face of this agonizing misery and suffering, the futility of academic discourse often appears overwhelming. I may say so, even worse. Because the level of discrimination that is being faced by third world global south countries is something which I might have to talk about it in a different video, but to basically talk about them through their experiences that they share on LinkedIn, the Anglophone world basically dominates a lot, and they are basically consider themselves racially much more intelligent, which is a very, very dangerous thing. We must hope, in conclusion, what I want to say is that we must hope that moral sensibility and rational argument can indeed coexist. In the face of evil, it is all too easy to descend into tenuous simplification and rhetoric when reflecting upon the proper nature and function of the law. Analytical clarity is especially urgent in times of turmoil when voice of the demagogue is the loudest. Scrupulous jurisprudential consideration of the most fundamental questions of law, justice, and the meanings of legal concepts is essential. Legal theory has a crucial role to play in defining, shaping, and safeguarding the values that underpin our society. The stakes are not low. We can do good, we can do well, we can do better. I believe jurisprudence as a subject can teach you how to rationally make arguments as well as moralistically evaluate the considerations before you take an action. So it's a very helpful subject. I will discuss lots about it if I get the time. I hope so I get it. I pray to God that I get it. But through these two-parted videos, I want to simply explain basic introduction to jurisprudence and basically to make you understand what law is, what the nature of law is, and I hope you have understood some bits of it, because jurisprudence is also a complex, tedious subject. It's overly, I may not say it's overly simplistic simply because it's written in English, but you have to decode the jargon as well. So it's like using a vocabulary side by side to decode whatever is being said to you, or basically to read something 2 or 3 times more to understand, okay, this is what the author is trying to clarify or to make his position. So it's hard, but it's an interesting subject, and I hope the journey will be very fruitful for our channel, the interactions that I'm doing. I hope to reach 50 subscribers, because then I would be able to do a live stream so that I can connect with you all more. And if you have any further questions or anything, you can post it in the comments. I will love to clarify it as much as possible that I know of. And please like, share, subscribe. And I am new to this whole YouTube family, so I hope they graciously accept me and not give me 3 copyright strikes because I'm making such videos, or I don't fall into trouble like nowadays where law students are getting into trouble talking about issues which are deeply polarized. So I tend to want to make it as academic as possible. So I hope you like it, and let's see in the next video what topic I have in mind, and I'll make about it and I'll think about it. And thank you very much. I'll see you in the next video.